have a reason to change that default, the estate plan is how you do it. Similarly, as I said, there are state rules that say who manages your estate, whether you're incapacitated or passed away. And if that default doesn't make sense, you can change it. You can put family members, trust advisors, independent people, and say who you want to handle things for you or for your family. Another reason to do estate planning is to have a plan in place that people are aware of. And it's not a guessing game what the state law is going to be. You know exactly who's going to manage things for you or who's going to take your assets if something were to happen to you. And then the last critical reason for having an estate plan, especially in California, is to avoid the dreaded probate estate. And you might not be aware, but probate just means going through a court process with an estate to make sure that the estate goes where it's intended and gets managed properly along the way. Unfortunately, depending on where you pass away, the probate process could be a couple months to a couple years. In LA County right now, I think the minimum time you're going to be in probate court is a year. And that's if it's simple and everything goes timely and no hearings get continued. More likely, it's going to be a 2 to 3 year process in LA County right now, especially with the delays from the court closures that happened over the last year. So making sure to have something in place that's going to not tie up your assets in court is really important for your intended beneficiaries. In addition to probate taking a long time, it can also be pretty costly. There are statutory fees that the attorney handling the probate or the executor that gets put in to manage your estate are guaranteed to get paid, and it's based on a percentage of the value of the estate. And then there are also costs for filing petitions or other documents with the court. And then for most people, one of the biggest problems is it's public. If you do an estate plan and you have everything set up, that can be private, and it could be just for your family or your trusted people. They could be aware of it. But if you pass away and a probate proceedings required, that's public record and anyone can request it from the court. So all of your assets are going to be known and their values, and your closest family members and any fighting in between them is going to come out, and it's going to be part of this public court process. Now, once you decide you want to do an estate plan, the next question is, well, what does that mean? What goes into it? What sort of documents are involved? And I'm going to hand over to Brittany to start talking about that side of the estate plan and what it actually is.
So oftentimes your estate plan is thought of as something that is effective after you pass away. However, there are several parts of your estate plan that are also relevant during your lifetime. I'm going to touch on 2 of those right now, and then we'll work into some of the other documents that are relevant for your estate plan. Now, out of those 2 documents that are most relevant during your lifetime, that's going to include your Advanced Healthcare Directive, as well as your Durable Power of Attorney. The Advanced Healthcare Directive is a document that allows you to appoint an agent and successor agents to act on your behalf. It's also the document where you're going to have statements regarding your desired wishes for your healthcare. So your Advanced Healthcare Directive tends to be necessary when you are unable to make medical decisions on your own. You're unable to communicate your desired wishes with your physician or with the healthcare facility. That's when they're going to look for this document known as an Advanced Healthcare Directive. You can oftentimes get these from a physician, or if you go into a hospital for a procedure, they often provide this type of form. You can also get one offline or online. Do beware though, whenever you are searching online, to look at least at 2 to 3 of the forms to make sure that you're getting one that has all of the points that you want to discuss with your agent and with your successor agents. Sometimes these documents aren't going to be viewed until you aren't able to communicate your wishes, so you want to make sure that it is a thorough form. You can also obtain one from an attorney. Now, when you're going through on your Advanced Healthcare Directive, it really is important to name an agent and successor agents. Please name more than one agent. But it is very important to name an agent who knows you, who will be able to understand your wishes and what you have communicated in that document. You're also going to want to name someone that is relatively local or at least in the same time zone, because if an emergency happens, the hospital or the doctor is going to be calling that individual, most likely on their cell phone, which you will want to include on the form. And it's important that they are available. I do try to recommend clients away from appointing an out-of-state relative or someone out of the country, because we want to make sure that individual is available if they are called upon. Now, some of the things that you're going to be putting in your advanced healthcare directive, they can be really broad, where you give your agent and your successor agents the ability to do anything that they deem necessary. They will be working with a physician, but overall, if you trust them, you can make it very, very broad. Now, with that said, you can also make it very restrictive. You can put things in your advanced health care directive that deal with pain management and that also deal with end of life decisions. It can be very detailed, and that is really okay. In fact, if you get one of these forms, say from a physician or from online or from your attorney, if you need more space, make sure to ask. This is critical. It is something that you want to make sure all of your desires are within this document that relate to your healthcare decisions. Another thing that is part of your advanced healthcare directive is direction involving the disposition of your remains. So that ranges from whether or not you want a funeral service or a memorial service, if you would like to be cremated or buried, as well as autopsy procedures can also be included in these forms, and organ donation. These are all things that are very important to sit, consider, and put in your advanced healthcare directive. Do remember that you can bring this to your physician's office. They're happy to look at them, as well as office administrators at hospitals and healthcare facilities. And on that note, a lot of people don't know, but you can actually submit your advanced healthcare directive prior to going to the healthcare institute or the hospital. You can also provide it to your primary care physician. Please do provide it to your primary care physician. But it's really nice that you can send it ahead of time to some of these facilities, and they will let you know if something is not clear or if they need additional information. So it's kind of a good way to have your advanced healthcare directive checked. Now, when we're discussing the advanced healthcare directive, I also like to mention the PULST document. It's the one that is normally a bright pink color. You've probably seen it. It's the physician orders for life-sustaining treatment. Now, that document actually needs to be completed with your physician. Your physician will need to sign it. But when you, or if you are anticipating signing a PULST, you're going to want to bring your advanced healthcare directive. It's really important that those two documents align. So having it with you when you're talking to your physician about a PULST, it can be very helpful. Now, the second document that is relevant during your lifetime is your durable power of attorney. Similar to the advanced healthcare directive, you can name your agent and successor agents. Please name successor agents. You can also go through and list important financial decisions and those powers to your agent. Now, the durable power of attorney is going to deal with financial matters, and that really can range. It ranges all the way from making sure that your monthly bills are paid, all the way to oh, sorry, I just saw a pop-up and I thought it was a question. So it can range from paying your monthly bills all the way to transfers of real property. And these are powers that you will find in the Advanced Healthcare Directive. Now, those forms are going to be a little bit more difficult to find, the durable power of attorney, that is. You're normally going to get that from an attorney's office. There are a few online forms, but when you're going through these in particular, because someone can really go in and take money out of your bank account if that power is within that document, you're going to want to be careful on signing this document without having it reviewed. But if you are going through and you're completing a durable power of attorney, one thing to consider is the agent that you're going to name. There are three mainly different types of durable power of attorneys. The first is known as a springing power. That's where it springs into action upon your incapacity. And normally your incapacity is determined via the document. There is some language within there for determining incapacity and when this document should spring into action. Now, if we have a springing durable power of attorney, we're also going to have a non-springing durable power of attorney, which is effective immediately. So that agent that you name normally is a spouse or a child or a really close family friend. That would be effective immediately. And then there's, of course, a combination, because why not? So you can have a springing power as to so many people and then a non-springing. So in other words, normally this is what we see is the spouse will have the power effective immediately, but then the children, you're going to need to wait until I'm deemed incapacitated, and then you can step into my shoes for financial decisions. Now, when we go over these documents with clients, I do like to mention digital assets are becoming a bigger and bigger thing. So please do beware. Normally, the durable or sometimes other estate planning documents will have a power within them regarding digital assets. But in the meantime, if you're not able to find one, it's a good idea to have a list of those accounts, a list of those passwords, and to have them in a safe location, but maybe let at least one person know where those are. It does come up, and that is an issue that we have to sometimes iron out with the various account holders. So something to keep in mind. Now, the next question is whether or not your estate needs a revocable trust. Living in California, you've probably heard your friends have a revocable trust. You might have a revocable trust. What is this thing and do I need it? So a revocable trust in California it's starting to become the default, and there's a few reasons of why, honestly, and I think they're pretty good reasons, not just career purposes. But the first is going to be probate avoidance. And as Erica mentioned earlier, probate it can be a very lengthy event. It can be something that you can't really count on as far as timing. We had a few matters that were probate before COVID, and as you can imagine, they've gotten pushed several times. And there's really not much that you can do. So keeping in mind the length of which probate can take, and then also the amount that probate can cost. As Erica mentioned, there are statutory fees for attorneys and executors, so something to keep in mind. But I won't hash too much on that since she did talk about it. Another thing with your whether or not to have a revocable trust is to consider the size and makeup of your estate. As she had mentioned, it is a public affair. It is something that a lot of our clients who have closely held family businesses or real estate, they don't really want a court or someone appointed by the court going through and inventorying their business, as well as conducting appraisals. I mean, this might be very private information, and a lot of people keep their wealth private that will then be available for public viewing. Another quick point on that is it does tend to happen after probates that the family members are solicited because people saw that they own real estate now or they own a family business now. So those individuals tend to be contacted. So just another thing to consider on those privacy matters. Also, you're going to want to consider whether or not tax planning needs to come into play for your estate. That would be another reason for a revocable trust. But the main reason, and what Eric and I tend to see most, is going to be the flexibility and ultimate control that you get from a revocable trust. So again, going into that family business or certain real property that you hold, if it's rentals, having the revocable trust does provide some additional flexibility for planning in the future. Now, depending largely on these factors, you can decide if you need a revocable trust or not. But to provide a little bit more clarity on what the estate would look like with a revocable trust versus without a revocable trust, Erica's going to walk you through both of those camps.
Yeah, so as Brittany said, there are really two different options for the makeup of your estate plan. You have option one, where you do an estate plan that centers around a will. And when your estate plan centers around a will, we call it a standalone will because it stands without a trust. The other option, as Brittany was talking about, is an estate plan that centers around a revocable trust. And really the difference between the two plans is what Brittany was talking about. It's the fact that with a revocable trust plan, it's likely to stay private. With a plan that centers around a will, the likelihood of probate is a lot higher, which will make it more public. And it also could make it a longer process to administer. But the other main difference between the two is how you hold title to your assets. With a plan that revolves around your will, you're likely going to try to put as many of your assets in a form that won't be subject to probate. So co-owning them with others or designating death beneficiaries so that they don't fall into that probate process. With a revocable trust plan, you try to put your assets in your trust. And for most assets, you can put them in your trust without any repercussions. There's no tax issue. There's no change for how you can manage your assets, even if they're held in your trust. The only exception to that is retirement accounts. Those need to stay outside your trust, but those have death beneficiary designations. So you don't have to worry about those falling into probate usually. So you could put everything else in your trust and just have the death beneficiary designations for your retirement or maybe life insurance if you want to keep that outside of your trust. So because of the probate issue in particular, in California, as we were talking about earlier, we're seeing people lean towards the estate plans that revolve around a revocable trust because they're more likely to be able to get around any sort of court proceeding at the person's death. But we're going to go through both of these in a little more detail just so you really get an idea of what could work for you. In the first scenario, where we're doing everything with a standalone will, the will is going to be where all of your terms of your estate are written out. So you're going to name someone to manage the assets at your death. That person's an executor. However, we should note you're only nominating them because a court's going to decide if they are, if they're a good person to actually manage the estate. And if they're not, they'll pick a different person. So it's a nomination, not a designation. You're also going to say how your assets are to be distributed when you pass away in your will. So you could do, very basic where everything goes outright to a couple people or to a couple charities, or you can make things really complicated and have a bunch of restrictions or trusts for individuals on how they inherit the property and at what ages they can get distributions. So you can do all of that same fancy estate planning inside the will. The only difference is if it has to go through that probate process to get to the subtrust for the children or whatever the fancy estate planning is inside the will, you're now subjecting that subsequent trust for your kids to court overseeing going forward until the court has decided that they no longer need to make sure things are going well. Whereas if you were to do this all in a trust document to begin with, the court wouldn't get involved until the beneficiaries or trustees had questions for the court. So that is the difference. If you do some of that more sophisticated planning, the standalone will probably isn't the best place to do it. The will is also where you would nominate guardians if you have minor children. And again, it's a nomination, but the courts do look very closely at who you're nominating. And if you have particular reasons for why you're nominating certain people, you should say that either in the will or in a side document that you keep with your will. We've also found it's really important you should let the people know who you're nominating, especially for guardian of your minor children, because you don't want any surprises where they aren't able to take care of your children for some reason, especially if they're going to feel very guilty about it when they really can't handle the situation. So you want to, get all of that ironed out ahead of time. The other thing where you have an estate plan that centers around the will, as I talked about, you're likely going to try to hold most of your assets in ways that are going to avoid going through the will and the probate. So one of the ways to do that is to hold assets with co-owners, where there's a right of survivorship. When one owner dies, it automatically goes to the surviving co-owners. So for instance, you've probably heard about holding things in joint tenancy with right of survivorship, or in community property with right of survivorship. I will say, if you have the option of holding something in community property with right of survivorship, that should be your preference in California. There's tax reasons behind that. I'm not going to bore you with them, but if you're buying a new house with your spouse and you get asked, oh, do you want to hold it in joint tenancy or community property with right of survivorship? The answer should be community property. So that's just a little tidbit that most people aren't aware of. So I always like to mention that one. So then, in addition to the will and real estate or other assets like that, you might also have assets that you don't co-own with someone. That it's your investment account or your cash account or your retirement or life insurance. You don't own those with other people, but if you want to make sure that they avoid probate, you need to have beneficiaries designated for them. So for an investment or a cash account, you can hold it as a transfer or payable on death account. It's a certain type of account. You just ask your banker to set it up that way, and they'll give you a form for designating a beneficiary for when you pass away. You always want to have contingents. Just like with successor agents or executors, you want to make sure you have successor beneficiaries listed. And then the same thing with retirement or life insurance policies. Those have beneficiary designations. You'd get them from the provider and fill them out. I always say make sure to check every once in a while that your bank or your life insurance provider has your designation still on file, because we've found that occasionally they aren't attached to the account even though you've sent them in. We also suggest mailing them certified mail, even though it's very old school. At least it gives you that evidence, or your family that evidence, that the designation should have been on file. And therefore, just because it wasn't on file, it shouldn't cause a probate, because the designation should stand. The other thing to worry about a little bit on those designations is most assets in their contract have a default. If the designation fails for whatever reason, they default to the owner's estate, and that makes them a probate asset. So you always want to try to put as many contingents as you can, including maybe ending with a charity or some sort of broad statement of who should take, because you don't want it to end up causing a probate when otherwise it wouldn't have. So that's the estate plan if you have a will as the central piece. But if you have a trust, things change a bit. So Brittany, why don't you take us through that camp?
Sure. And Erica, just before we go there, I think I've picked up on how the comments happen. It looks like you have a question regarding community property versus joint tenancy. This is from Jackie. What was the community title called? We have joint tenancy and may want to change.
It's called community property with right of survivorship. And that right of survivorship is the key part. You want to make sure that's on the deed, and that will guarantee that it will go to the surviving spouse at death, but also count as community property for income tax purposes.
There was also another question that came in, and that is, what is the best way to protect assets from Medi-Cal reimbursement?
So one of the ways is to have them in your trust, if you have a trust. Non-probate assets are usually better protected than probate assets, if you look through the rules. But I will say, if you have a desire to do any sort of planning specific to benefits or reimbursement rights of different government agencies, you really want to find an estate planner that has a specialty in benefits planning, or what we call elder law. It's called that, but in reality, it's really the law of dealing with government benefits and those in society that are unfortunately more suggestible under the law. That if they do things the wrong way, the government can get access, or they could lose benefits or other things like that. So that's all we mean by suggestible in that field. But you're looking for someone with benefits or elder law specialty.
Perfect. Okay. Now, Moving on to Camp 2, and this is going to be the estate plan with a trust. In particular, we're talking about a revocable trust here. You may have learned there are several different types of trusts, including irrevocable trusts, but when we're going over this presentation, we're really referring to your revocable trust. And one thing to note about a California revocable trust is it will look different, depending on whether or not you are married. You can have one revocable trust, you can have multiple revocable trusts, but if you are married, that is something to take into account because tax planning, of course, and you love them. But moving through your revocable trust, it is exactly what it sounds like. It is completely revocable, amendable. You can terminate it all during your lifetime. And so long as you have capacity, you can even redo the entire trust, and that's known as a restatement. A few important features to know about a revocable trust is it is going to look a little different than the camp that Erica just mentioned. And here you're going to have a trustee. So that's the person that will be managing your estate and your assets. They do have a similar role to an executor, but it is a little bit more detailed in the revocable trust because you get to lay out all of the powers and you get to lay out their duties and tasks and things that you want from them in particular. They will also have the job of marshaling all of the assets after you pass away. They will pay debts and expenses, and they'll also communicate with your beneficiaries. So when naming a trustee and successor trustees, as you might have noticed, Eric and I are a little sensitive to please name more than one person for an agent. Please name more than one beneficiary. We've run into too many instances where there just was no one else named. So please do. But when you are naming your trustee, you will want to think of someone that will work well with your family members. But then again, you can also name a corporate trustee if you would like. You can name a private fiduciary as well. A corporate trustee is going to be that banking institution that you're thinking of. Most big banks nowadays, and even some smaller credit unions, do have a trust department, and they can act as your trustee if you appoint them. You can also name a private fiduciary, which is a private individual that is licensed to handle trust matters. There does tend to be a little bit of a cost difference there, but with each decision you make, as far as your trustee is concerned, interview them, talk to them about what their thoughts are on a particular asset that you have, or a hypothetical one at the minimum. Getting an idea of how they will handle things will really help you work through some of the questions that will be posed to you whenever you are drafting your revocable trust, or if you're speaking with an attorney to draft your revocable trust. And of course, one of the more important things about your revocable trust is it will dispose of your assets. Now here, as opposed to the standalone will, you have quite a bit of flexibility. It is also not overseen by the court unless a beneficiary or the trustee asks the court to step in. And another positive to remember about your revocable trust is, along with your other estate planning documents, it can act in the place of a conservatorship, which is subject to court oversight. So again, just another positive for your revocable trust or drafting one. Something else that will go along with your revocable trust is known as a general assignment. And really, it is you generally assigning your assets to your revocable trust and saying, my revocable trust is the owner of this particular asset. Now, if the asset has its own legal title, so think of your securities or investment accounts, think of real property, of business interests, you're going to need to retitle those assets themselves. So make sure to follow up with that next step. The general assignment isn't enough. You're going to want those additional assignments or a deed to have the proper title on that asset. Now, along with your revocable trust, you're going to have what's known as a pour-over will. It's a little different than the standalone will, of course, not in just its name, but in the way that it works. Your pour-over will is just as the name suggests. It's the will pouring over those assets into your revocable trust and saying, please follow my revocable trust in disposing of these assets. In the last part I want to touch on is in regards to the retirement and insurance beneficiary designations. I know Erica went through those in quite some length, but just something to keep in mind when you are naming your beneficiaries for those two things, the retirement and the insurance, because they do function via contract. So you're going to want to name the beneficiary right there within the retirement and the insurance. But keep in mind, if you do name your revocable trust as beneficiary of either of those, there are tax consequences and a tax analysis that we perform with each client in regards to their retirement and their insurance. So before you go and name your revocable trust, I really do recommend seeking out some advice, whether that be with your CPA or your accountant or with your attorney. And now, speaking about tax planning, we would be a little remiss to not mention a few of your options here. And as such, Erica's going to walk you through those.
So what we've covered so far applies to everyone. You know, talking about everyone has some estate, whether it's they have a house and a cash account, or they have a ton of investments in a small business and maybe a real estate empire. Wherever you are on the spectrum, you have an estate. But there are also other things to talk about in the estate planning realm. And some of these might be of interest to a few of you. So we want to at least mention them in a little bit of detail in case they are, and in case you have questions. You probably are aware that there are a lot of tax laws. They're vast and they're complex in our country, and they change from time to time. In the estate planning world, we see families that focus on many different parts of the tax world in terms of what the focus is for them on tax planning. Some clients focus on the federal gift, estate, or generation skipping transfer taxes, which are what we call the wealth transfer taxes. Those are the taxes on transferring assets from one person to another, and whether or not that gets taxed depends on many different factors. For instance, there are exclusions that can apply, deductions, and then if we're talking about something large, you know, we have this estate and gift tax exemption, and under the current rules, it's very high. It's about 11.7 million per person now. So it doesn't affect most of the country, but I do know there are people worried at the moment that there could be tax reform on the way. If that were to happen, one of the things that's being discussed is a reduction of that exemption back to about 5.5 million, or maybe even lower, depending on what Congress decides is reasonable given the economic situation of the country. If you have more than that exemption amount that you're gifting or transferring to others, then there's a 40% flat tax on that excess. And so that's why estate planning and tax planning can be really important, because that's a high tax. And there are ways to transfer things, not necessarily to avoid tax, but to reduce the overall tax bill that your beneficiaries or you might have. And they're all very legal and very well-documented things. We're not talking about anything risky or anything fraudulent, but there are options to consider, and they probably should be taken into account if you have estates that are over about the 5.5 million mark per person nowadays. It's also really important to let you know, California does not have a gift, estate, or generation skipping tax themselves. It's only the federal tax to worry about. There was some talk a couple years ago about California creating an estate and gift tax, but they never did it. And it's unlikely that that would have any more traction if there is tax reform bringing the federal exemptions lower again. So I think we can all breathe a little sigh of relief in California that we should focus on income and property tax issues and not on transfer tax issues at the state level. But that actually brings me to some of the other taxes that people worry about, which are income taxes. There's both the federal and the California income taxes to think about. And then also property tax is a really big deal in California. And, you know, I don't know how many of you are aware, but there is a pretty big property tax law change that came out of the November election that goes into effect mid-February, and it changes the reassessment exclusions that were allowed when transferring property from parents to children or grandparents to grandchildren. So it is another thing now to take into consideration when deciding your estate plan, because before you might have said, oh, my kids are going to keep my house, it'll get to them without any reassessment. Well, that might not be true anymore. So maybe the house isn't the right thing for them to get. Maybe you should plan the house is going to be sold, or maybe you should consider trying to transfer it sooner or in stages as opposed to all at once at your death. So those are
Erica,
just
really quick on that point. We had a question to it actually. Do you know if it will be retroactive, the Prop 19, if there's going to be a clawback to January 1?
There is not a clawback to January 1, but the main problem with it is it's based off of when the change of ownership is deemed to be effective. And with recording rules in California, it's when it's recorded generally. If there was a death that's associated with it, it's back to the date of death. So, you could be recording a deed from a death 5 years ago, you're going to get the change of ownership 5 years ago. You don't have to worry about Prop 19. But if it's something current, and even if you do it February 15th, the law change happens February 16th, the likelihood of you being able to get that recorded in time is very small. I know we're facing LA County, I think they're delayed about 10 weeks right now, which is already too long. So we're trying to come up with other options of how to define that transfer date. And we think, especially given these delays due to COVID, that there'll probably be some buffer period, grace period. We just don't know what it's going to be yet, because each county is affected differently right now with these delays, and this is a state law. So it needs to be fair across all the counties. So we are expecting some leniency, at least through the February 16 date. But after that, any further transfers, it's going to be under the new law for sure. Okay. So the other thing that I wanted to mention, besides the tax planning, is charitable planning. And that could be for tax purposes, or it could just be because you're charitably minded or your family's charitably minded. And there are many different vehicles to do charitable giving. You can do gifts just of cash or property in kind, or you can do pledged gifts over time, annuities. You can set up a donor advised fund where it would make donations for you every year, but you put in money, just you front load it. And then for years, you can be giving from that one account. Private foundation works similarly, except you're operating in essence a business or a charity. Or there are fancy trusts that you could use for, if you want tax planning as well. You can do what we call charitable remainder trusts or charitable lead trusts. There are lots of options, and I don't want to get into them in a ton of detail, but I did notice CSCP's website has a really good planned giving portal and a lot of good brochures on there that explain what these tools are, not just in terms of using them for this society, but for other charities as well. It's just a good place to go for information. And I do think that, I think Patricia is on the call, and I think she just wanted to spend a couple minutes introducing you to the Legacy of Hope for CSCP.
Yes, thank you, Erica. Thank you, Brittany. CSCP does have a Legacy of Hope Society, and this is a group that is comprised of people who remember CSCP as a beneficiary in their estate plan. And this is a very special group to us because it ensures that future generations of people who are going to be impacted by cancer will have the resources that we provide. And as Erica said, our website under Support Us does have a pretty comprehensive section on planned giving. We encourage everyone who is interested in making legacy gifts, charitable gifts, to consider joining our society. Melissa Elkhorn is on this call, and she's a member of our board of directors and the chair of this committee. And I just want to point out that sometimes people get nervous when they think they have to have a huge estate to leave a portion of it to a nonprofit organization. That's not true. I've been here since 2015, and we have received legacy gifts that range from $1,000 up to $200,000. And the majority of them have been at the lower end. But they're very important because it ensures that if there's a financial downturn, if there's a crisis, if there's a pandemic, we have funds, we have a reserve account, we have an endowment that we can turn to if need be to make sure that our services, our free services, are not interrupted. So if you're interested, reach out to me, reach out to Judith, our development manager, or reach out to Melissa and check out our website. Thank you.
And we had just a couple questions that I skimmed over. Erica, if you don't mind, we can just go back to those really quick before we go through our quick little summary. So it looks like with community properties with right of survivorship, can that apply to siblings owning a property, or does it only apply to spouses?
It only applies to spouses, unfortunately. Community property is something specific to spouses co-owning property together. But if you have siblings that own property together, you have a couple options. You can do the joint tenancy with right of survivorship. That will at least get you that operation of law survivorship designation if you don't have a revocable trust. Or you could co-own the property as tenants in common. And what that means is you simply each own a particular percentage of the property, and you can do whatever you want with your percentage. And if you want to lay some ground rules, you can have some sort of a co-ownership agreement or put it in an entity, an LLC or a partnership, to have some sort of agreement of who you can leave it to. But under a tenancy in common, you do own your particular percentage, and that value can go to whoever you want it to go to at your death, whether through a buyout from your siblings or just your beneficiaries take it in kind. Whereas a joint tenancy, it's going to go to the surviving co-owners.
Perfect. Our next question is how much can a person own in California besides those with designated beneficiaries for a probate not to become an issue?
It's about $170,000. And the idea is it's what we call probate assets. And once you aggregate all of those, if you go over about 170,000, then you're going to actually have to go to court. If you have under that amount, there are different affidavit procedures that can be done that might not involve court real estate. So if you have small value real estate, there's still a court process, but it's nowhere near as involved. It's still an affidavit. You just actually have to file it with the court. And then in terms of what counts as a probate asset and what doesn't, the real key is, does it have someone that it has to go to under law? So whether it's the designated beneficiary under the contract with the institution, or is it a right of survivorship situation through joint tenancy or community property?
Perfect. And I think that is all the questions that we have so far, but I'll look back once we're done with our presentation here. So I'm going to touch on really quick the process of developing a plan, and these are just some pointers that Erica and I put together. So before meeting with your attorney or developing the plan on your own, it's very important to know your assets. And in order to really know your assets, you need to collect the most recent statements. You also need the most recent beneficiary designation forms. I highly recommend reaching out if you have life insurance or a retirement account. Reach out to that financial institution and ask them to send you the most recent beneficiary designation form. You would be surprised how many times people are surprised by who is still on those forms. So making sure that those are up to date and knowing that information before you either start developing your own plan or meeting with an attorney can really save a lot of time. Also, talk with your accountant, your CPA, or your financial advisor. You've most likely been working with them for at least a few years, if not a decade or more. They know the ins and outs of your estate. They most likely will have some type of recommendation that you can at least start from and mention that to an attorney if you are meeting with them. It's valuable information, and we really do rely on financial advisors and accountants to be part of the team so that we can effectively put a plan in place for that particular client. Also consider involving your children. It does help quite a bit to have the children involved, to allow them to know what the plan is, um, and know what to expect. It tends to be the beneficiaries who were never informed who tend to have the most issues and either need a lot of hand holding, which is fine for some instances, but if you're hiring a law firm, that can get expensive. Or it's those beneficiaries that want to contest as quickly as they possibly can because they know mom and dad loved them a lot more and they were entitled to more. So just something to think about of keeping that communication line open with the children. It does help later, considering I see that other side quite a bit. Another thing to do, like we've been, I think, saying this over and over again, is to have a list of successors in mind. If you are looking at developing your own plan and you're considering naming your accountant or your financial advisor as a successor agent or a trustee, one thing to keep in mind is oftentimes their liability insurance will not allow them to act in that role. So again, another reason to name a couple successors after those individuals, just in case they're not allowed to serve. Now, I think, yep, we're good on that. The next thing with developing your plan is going to be, sorry, I need to just switch slides on here. There we go, perfect. During the development of your plan, again, those successor trustees and executors, if you are working with an attorney to develop your estate plan, ask for referrals. If you're unsure of who to name for your trustee, they will know either the right banking institution or financial institution or a private fiduciary that may be a really good fit for you. Use that to your advantage. Ask them for more than one individual or more than one company. They will have a Rolodex full of people there. You're also going to want to consider what type of assets to pass to what type of, or to what particular beneficiary, and if that beneficiary needs any special provisions or guidelines in handling the assets. So oftentimes we recommend a secondary, or you can have more, personalized letters from you to the beneficiaries or to your successor trustees of maybe you've had really great success with rentals and here is your philosophy, and you hope that they take this into consideration when making decisions in the future. Similarly with children, if you know that one child may need help compared to the others, then put something in the document to that effect to really reiterate to the trustee again, hey, I think some special attention in this manner may be necessary for this child or for this beneficiary. Those side letters really do help and are things that can be relied on later when there is a question of what your intent might have been. Now, Erica is going to discuss a few other points with you on going through and developing and finalizing, or I'm sorry, once you've actually finalized your estate plan.
So what we've talked about today has been leading up to, okay, you have documents in place, you've done it, your affairs are in order, as we like to say. But there are some things that you should do from time to time to make sure that your estate plan is still in working order for you. So one of the things that we recommend, just as a starting point, is keep your estate planning documents in a safe location, somewhere that you can access, somewhere that you've told your successor agents, trustees, executors where it is. Maybe you tell your CPA and your attorney where it is as well, but put it somewhere safe, because there's actually a law that says if you mark up some documents, that could be presumed to be your intent to destroy the document. So it's really good that, at least for the originals, that you keep those clean. Feel free to make as many copies of your documents as you want to and write all over those. In fact, I love it when clients actually come in, we're doing a review of their estate plan, and they pull up their copy and you can tell that they've thought about it because they have notes in the margins of their copy. So we actually have a really good meeting because of that. But you want to have it somewhere accessible that you can go back to. You also want to make sure that you give a copy of your healthcare directive to your primary physician if you have one, and to a hospital or health center if you're going to go in for any sort of treatment. It's really good for them to have that on file. So one thing we like to tell clients is print out several extra copies of your healthcare directive. You never know when you're just going to want to throw it in your purse and take it with you somewhere. So that's good to have. It's also good to give a copy of it to your agent. Even if your power of attorney for healthcare isn't effective until you can't answer a question, it's still better for them to have easy access to it. Maybe you just email them a copy, and one day when they need it, they can search their email and find it, and they know that you don't want certain types of support. Well, it's right in there, and they know that at the time. The other thing we like to let people know is it's good to review your estate plan in full every 3 to 5 years. And what that means is simply going over the terms again. You don't have to meet with an attorney every time. It's just making sure that you skim through it and make sure the beneficiaries still make sense. Make sure that the terms of how you've left people their inheritance still make sense. If you're drafting your plan while your kids are minors and now they're in their 30s, it might not be the right plan anymore. Similarly, the trustees might not make any sense anymore because now your kids might be ready to handle that role for you. We've also found 3 to 5 years is about the average of time that big changes will happen. Kids go from junior high to high school to college, for instance, in those sorts of intervals. And the other thing to know on reviewing and updating your plan is your power of attorney documents for healthcare and financial power of attorney. Those can be deemed stale by the institution or provider. And it's really up to them if they decide, no, this doesn't look like it's current wishes anymore because it's X years old and they have whatever policy they have. Legally, that's not the case. It should still be effective. But in the time of need where they're looking at it and they think, oh no, this is probably outdated and they might not follow it, it's better even just reprint the document, sign it again with a new date every few years. That way there's no question you have something up to date whenever you go in for something. So that is everything we had prepared to go over with you guys today. And first of all, we want to thank Rachel and CSCP for inviting us to do this talk. But I also wanted to open it up for questions again in case any additional questions have come in or you were waiting till the end to ask a question.
So we do have a couple to start with in the chat. And how about we start there, and then if people would like to speak up, we can go to those. So the first is, if I don't own any I do not own property. So I was told by an estate planner that I do not need a living trust. Is that correct?
So it can be. So when you say you don't own property, I assume you mean you don't own any real estate. There are a lot of other types of assets. As we talked about, you can manage an estate plan without a revocable trust as long as you make sure to have designated beneficiaries or co-owners with right of survivorship and still avoid probate. So there is a way to do it. We just want to stress, make sure that you have, as we talked about before, contingent beneficiaries in place or other things like that, so that if something goes wrong with the current people listed, it's still going to be able to pass without probate. So you're right, you might not technically need a trust for the type of assets you have, but you might still prefer to have a trust because then you don't need to worry about beneficiary designations getting lost or running out of contingents. If the accounts or whatever are held in your trust, that will govern where it goes, and you can draft 12 or 13 contingencies deep and end with charities that support certain things, or end with family members, but without having to go through the probate to get there. So there still could be a benefit to the trust instead of relying on the beneficiary designations.
So this is in regards to Prop 19. So if you deed your property before February 16th and it's not recorded in time, is there a way to make that deed contingent on it being recorded in time?
Now, I haven't heard of that idea.
Yeah.
It is a clever idea.
I like the idea.
That you
Yes.
could be an estate planner right there with planning like that. I think the better thing to do would be to set yourself up in a way that if for some reason it gets reassessed, that you have a good pile of documents that you could show the assessor's office to say, no, this transfer really did occur ahead of that February 16th deadline. I've actually talked with a couple of the property tax experts in LA County specifically about this issue of the delays of the recording office and wanting to make sure that our clients' transfers get considered as before February 16th. There are a couple routes you can go. One is to get a title insurance policy. And I know what you're thinking, those are expensive. Why would I bother with that? We know we have good title. Well, title insurance companies seem to get things recorded day of, regardless of the COVID delays. So pay the extra, grand or whatever it is, and the due diligence of them checking your title to be able to get them to record for you. That's one way to go. If you don't want to throw money at the problem, most people don't. The idea of it's a bit absurd. The other option is to document things as well as you can. So what we're having clients do is, in addition to the deed, which is a document that gets signed and notarized and recorded, we're also having them sign an acknowledgement. So we have a document saying, I'm transferring the house to my child, and then the child signing and getting it notarized saying, I have accepted the house on this date. And so if the assessor decides that for whatever reason the recording got delayed, it happened after February 16th, they reassess the property and you have to appeal it or at least argue it with the assessor's office, you can pull up this document. It's been notarized. Notaries can't lie on what day they did that. So, or else they have their own penalties and issues with the government. So that's a document that the county is going to have to contend with as being in the file. And so what we've found for the property tax experts, this is what they're doing with their clients, is these extra documents that are notarized and just sitting in a file just in case.
Perfect. Now, a question regarding what is the best way to provide resources for a grandchild who is a minor?
There are a couple. It depends what type of resources and for what needs. You've probably heard of 529 plans. Those are educational plans. And you designate someone to manage that account for the minor. And then if the minor, they finish their education, well, it can be transferred to another beneficiary for their educational needs. So that's one way to do it. Another thing you could do for, and I should say that counts for the annual exclusion for gift tax purposes and for generation skipping purposes. A grandchild is what we call a direct skip, someone more than 2 generations away from you. And so you have to worry about that other tax rule as well as the gift tax rule. But it counts for both annual exclusions, which is great. You can gift $15,000 to any individual from you and from your spouse each year, and that counts under that annual exclusion. So a 529 plan, if education is the idea, you can do custodial accounts, what we call uniform transfer to minor accounts, UTMA, where you designate a custodian. And you can, again, make annual gifts to a UTMA account. One nice thing I should say about 529 plans, though, is you can front load that with 5 years of annual gifts, and you won't get penalized for gift or generation skipping purposes. So you can give 5 years of gifts in year 1, and as long as you don't make any additional gifts to that grandchild in those next 4 years, you can do that all tax-free. Another thing that we see a lot for grandchildren are irrevocable trusts that qualify under a special rule to still qualify for that annual exclusion for both gifts and generation skipping purposes. And with that irrevocable trust, you have a lot more flexibility in the terms and who manages it. So that's why we see a lot of clients picking that trust as opposed to a 529 plan or custodial account. And it's also another way that the funds don't have to just be used for education.
Perfect. All right, and I think that, Rachel, did I miss any? I was trying to keep up with them. And Erica, would you mind going to the next slide, please?
Oh, sure.
Thank you.
I think that's everything, because we had a perfect closing question of, can we contact you directly? So there is contact information for Erica and Brittany. And I just want to thank you all for sticking with us a couple of minutes past the scheduled end time, and especially a big thank you to our presenters for your generosity in answering questions and staying on a bit longer. We really appreciated this informative presentation. So thank you so much for your time.
Oh, no problem at all. This has been a lot of fun. And as we said, feel free to contact us. We're happy to answer questions. We gave you our email addresses there. If for some reason you want a phone number, I'm sure Rachel can get that to you too.
Thank you so much. For those of you that can stick around just one extra minute, we have a poll that we're going to be doing as a workshop review that I'm going to launch right now. And thank you again to our presenters.
Bye.